This is Chapter 1. Liquor Liability. Section 1. Risks to security professionals. In this section, we will discuss all of the different liability that a security professional may be susceptible to. First of all, what is liability? Well, liability is defined as a hindrance that puts an individual or group at a disadvantage, or something that someone is responsible for, or something that increases the chance of something occurring. That means, liability is the cause of a disadvantage that incurred upon a person or group. Every time that a liquor license establishment opens the doors, risks to the owner, management, servers and security professionals begin to present themselves. There are three types of liability that every security professional needs to be concerned with. The first is administrative liability, and administrative liability applies to the holder of a liquor license and to servers who sell alcohol within a licensed establishment. And administrative liability is usually the first form of liability that licensees and their employees will experience. Each state has developed penalties associated with non-compliance of the laws. Common grounds for these penalties include failing to check IDs, allowing underage patrons into an establishment, and an intoxicated patron remaining on the property. Penalties for violating the terms of a liquor license or the conditions associated with a server-seller permit can include fines and up to suspension of the license permit. City and state governments enforce the administrative liability through various means. Basically, administrative liability is really state-issued fines for crimes against the code. The next liability that you need to be concerned with is civil liability. Civil liability allows individuals to bring a civil lawsuit against licensees, servers of alcoholic beverages, and/or security professionals. Most commonly, lawsuits are filed by the innocent victims, and/or by the families of innocent victims. However, an intoxicated patron could file a lawsuit as well. Juries typically award monetary damages to compensate victims and to punish the offender. Settlements can range from a few thousand to millions of dollars. Civil liability is based on two different forms of law: negligence and dram shop laws. Negligence laws deal with negligent behavior on the behalf of the security professionals. For example, it is assumed that a security professional can be expected to follow a set of procedures, and if they fail to do so, the security professional has acted negligently. Next is dram shop law. These laws are designed to make the seller of alcoholic beverages liable for any harm caused to a third party by a patron to whom they have sold alcohol. Dram shop law is intended to promote responsible alcohol service and provide a means for third parties to file suit for injuries and for fatalities resulting from a liquor law. Security professionals do not have to be concerned with dram shop laws like servers of alcoholic beverages, but they do need to be concerned if and when an intoxicated patron attempts to drive. This could cause dram shop liability for the establishment. And finally, criminal liability. Did you know that you can go to jail for breaking the laws while at work? Well, guess what? You sure can. Criminal liability allows the state to bring suit against the licensee or owner of a licensed establishment, individuals employed by that establishment, or employers. These suits, unlike civil suits, address the criminal aspect of the security professional's position. Please note, many cases involving injury or death result in both civil and criminal charges. The cases would be decided independently, and the penalty in either case is not dependent on the other. Also, while a civil suit typically carries a monetary judgment, the result of a criminal suit can be prison time.